Honor, from my office and see if I have a plea agreement ready to go. And if I don't, then yes, Your Honor, if he wants to take it, we'll write it up.
And I will say, this plea agreement predates me, so this is from January. Is what? But
Yeah, I just want to check my notes on it.
I remember it was set plea trial.
Last cycle?
Last cycle,
Yeah.
and then there was a capious at docket day.
Yes, Your Honor. And again, the state would have to be willing to honor it, but I do believe we had something worked out that he could have taken that was slightly different. So I would just like to consult my notes if the court would allow that. And then if I'd be able to grab my file at my office, take me just a few minutes.
I'm not even sure why he got put on this docket, to be honest with you.
That I don't know. Yes, I can't answer that. I understand he has a failure to appear, obviously, but I don't know why he would have been on today's docket.
All right, well, what do y'all want to do? Do you want to?
Pass him, Your Honor.
All right, well, let's make sure you get back in time.
I will.
All right. We'll pass it until later today.
All right.
Just have one.
Good morning, Judge. Judge, this is a Key Moore, case number 2024 CF 2048. Judge, we've been negotiating back and forth on this case. It was set, though, for plea or continuance. I've spoken with his father. In fact, his father was in court earlier today.
Just to correct you, it's 24 CF 2046.
46. Any rate, Judge, we're going to have to continue it, but we're trying to get it in for a landing.
Where are we at with it? This is now over a year old.
Judge, most of that time frame was when he was in failure to appear status. We're just trying to negotiate it out. His dad has some plans for things that might help him. He wants to meet with Ms. Leone, and he's not a permissive parent by any stretch. And so we're thinking that might result in something that will actually deal with the underlying problem. He's also got some certificates of participating in different betterment activities that he's going to get to me. Not Mr. Moore, but his father, Mr. McKinnon.
All right, State, anything? 10:29, 9 o'clock. Is there anything else that needs to be done in the case other than you're trying to work it out?
Judge, I'll go ahead
mitigation
and
that you've
set
talked
Ms.
about?
Phillips for deposition as well.
Okay.
I'll check and see if she was set originally, but I don't think so. Or so I don't think we took one.
All right, 10:29, 9 o'clock.
Thank you, Judge.
But you know, being in capious status for a long time is not really a reason for it to linger on for that long. I know you've got work to do, Mr. Williams, but
Yes, sir.
you know, things still have to move.
Yes, sir. All right.
Your Honor, this is Jason Walterman, 24 CF 1518. You asked to put him on towards the end of today's
Yeah, I
docket.
just didn't want to do the Faretta hearing because it takes a while and leave everyone else waiting.
Yes, Your Honor.
All right, Mr. Walterman, what are you asking the court to do?
Dismiss these charges.
Well, that's not what we're here for. No, that's not going to happen. I don't get to dismiss charges unless a motion is filed.
Yes, I filed a motion to suppress and a motion to dismiss. I guess it's not reached again, the mail for the jail.
Y'all seen anything?
Second time I've submitted it.
Well,
Right.
the issue is, Mr. Walterman, is that you're represented by counsel. And so
Yes.
when you file things, when you're represented by counsel, unless they're adopted by your lawyer as motions they want to pursue, then they're a nullity. It's like they never happen. They get struck. So other than dismissing the case, what are you asking for?
You reviewed discovery, see it's been amended several times due to the unlawful traffic stop. Everything that's supposed or alleged evidence is inadmissible in court. The charges are completely fraudulent. I did not possess a gallon of methamphetamines nor a gram of fentanyl at all. It was a targeted,
Mr. Walterman,
yes, sir.
earlier you said you wanted to talk to me about either representing yourself or getting a different lawyer. So that's what I brought you back to talk about.
Yes, sir. Yes, I asked council to put these motions in with the case law, and I did all the work and told her about it. She didn't submit it, so here I am. I guess I need to represent myself. I don't
your
want to
right
be
hand.
another statistic.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
All right. Can you state your full name and date of birth?
Jason Michael Walterman, 12/13/79, I'm 45 years old.
Okay. And so, Mr. Walterman, do you understand that lawyers have an ethical obligation not to pursue motions that they don't think that they can't in good faith think they're going to win? You understand that?
I realize that it's working against me, that's for sure.
That's not what my question was. My question is, do you understand if you ask your attorney to file a motion that he or she says, I don't think I've got a good faith basis to file, they're not going to file one because it would be unethical for them to do so?
I guess that's why we're here today,
Okay.
needing to relieve
But
my counsel.
again, my question is, do you understand that?
Do I understand that it's, that she didn't want to put the motion in for me?
I asked you a question. I asked if you understood it. That usually involves a yes or no answer.
Yes.
Okay, so you do understand that. So you've asked to file, or you've actually filed your own motions, but since you're represented, they're a nullity. Okay?
I must submit those?
Unless you're representing yourself. But I have to go through what's called a Faretta inquiry to find out if I think you're able to represent yourself. So, again, what are you asking for today?
I would like to represent myself. Do not
Why?
believe that the council has my best interest at heart or.
All right, so the issue, do you want to represent yourself, or you just have an issue with your current counsel?
You know, I realize the state's attorney's office is running the whole program between the sheriff's department, the public defender's office, even the outreach or conflict counsel. And, you know, as much corruption as I've seen them operating at, I don't feel safe with any of them handling my life. Manufacturing charges, tampering with evidence, falsifying police reports and certified documentation, targeting individuals, me especially, defamating my character publicly, personally.
Why do you think you're being targeted?
That I have not figured out yet. I'm stuck with no resources, you know. I don't have any law library, real.
Yeah, but you understand that you're currently in jail because you failed to appear for your
Yes, sir.
trial date.
I sure did.
So are you trying to represent yourself?
Yes, sir.
That's what you want, okay. How far have you gone in school, Mr. Walterman?
Almost the 12th grade.
Ms. Rivers, you can take a seat if you'd like to. All right. And don't, if I ask to verify information, I'm not trying to be offensive or anything like that, Mr. Walterman, but what you said was you didn't finish high school.
No, sir.
Did you get your GED?
No, sir.
And do you have a career field?
Professional construction worker, supervisor, superintendent.
Okay. And when's the last time that you've worked?
6 months ago, something like that. I've been in jail for about 5 months now.
Okay.
This has cost me 2 jobs already. My vehicle, my place to stay
that's-
twice.
I'd appreciate if you would just stay on track with what I'm asking you, Mr. Walterman.
Yes, sir.
Have you ever represented yourself before?
No, sir. Not in a court of law.
Okay, even in a traffic ticket or anything like that?
I don't believe I've been to no traffic court.
Okay. Do you understand that you have a right to a lawyer?
Yes, sir.
And you understand that one has been appointed to you already?
Yes, sir.
But due to your concerns about what you said with the corruption, you'd like to represent yourself, is that right?
Yes, sir.
Even though the state of Florida pays for the lawyer for you?
Yes, sir.
Okay. And do you understand the advantages of having a lawyer?
No, sir.
Okay. So, say again?
I said, no, sir. I haven't received any advantages.
Okay. So a lawyer's legal knowledge and experience may favorably affect things like bail and pretrial release possibilities, may result in obtaining information about the case through skillful use of discovery devices, may uncover potential violations of constitutional rights, and take effective measures to address them, may ensure compliance with speedy trial and statute of limitations provisions, and may identify and secure favorable evidence to be introduced later at trial on your behalf. Do you understand all those things?
Yes, sir.
Okay, but you don't want to have a lawyer do that for you?
Constitutional civil rights have been violated to a serious degree already. I think I got my best interest at heart. If I had the law resources, I could skillfully and professionally present the actual facts of the case, and that should be enough to abolish my charges and set me free.
What do you know about the Florida Evidence Code?
What I know about the Florida Evidence Code,
Yes, sir.
I can't say that I know anything about it.
Okay.
I haven't had access to any of my evidence except for the discovery. And then the times that I discussed my discovery with my counsel, the discovery got re-amended again and again.
Okay, but how do you think it's been amended?
It says so right in
I understand, but what changed?
the amount of people that was at the stop to begin with.
Why do you know, how do you know how many people were at the stop?
I was present.
Okay. Because I'm reading in your motion that you filed to suppress evidence that you said there was 12 to 15 law enforcement officers on scene within 6 seconds of them pulling you over.
Yes, sir.
So
We were
what's the,
sitting still in a parking lot when they come into the parking lot with no lights.
I'm not asking you about the facts of your case, sir. I'm just trying to make sure I understand your issues with discovery.
Yes.
If you know that there was 12 to 15 law enforcement officers there, what's the issue with them amending to make sure all of them are listed in discovery?
Well, they didn't present the evidence until I said something about it. There was just one account or two accounts of an officer on the scene where it took me saying something for them to add some more officers on there, which still there's only one account of video footage. When there's that many officers on the scene, there should be that many video accounts plus their vehicles. You know, they exist and they were there. That's part of the evidence that's not being presented. Also, the arrest report has Jason Walterman. My name is Jason Walterman, spelled wrong. My description is wrong as well. And there's many discrepancies and false statements in that arrest report.
Whose case, is this Ms. Leone, is this your
This
case
is
or
my
Mr.
case,
Sheik?
Your Honor.
Mr. Sheik, do you know how many discovery exhibits the state has filed?
I believe there are the original discovery and then 2 amended, Your Honor. One was just adding more of the officers that were present on the scene, and then the other one was the FDLE report, Your Honor.
Okay. So, Mr. Walterman, I'm looking at the discovery exhibits because you said they've added a bunch of officers.
No,
From
they
my, hold on. From my reading of it, the only one they added on the amended discovery exhibit was a Deputy Langer. Everyone else was already listed, and if you read on the actual exhibit, it says, this amended discovery adds previously unlisted Deputy Sheriff Langer and recategorizes the deputy sheriffs who were previously disclosed in initial discovery dated 8/6/24. So it only added one person. It just recategorized people as they need to be under Florida Rule of Procedure 3.220. The second amended discovery added an FDLE chemist, who I'm assuming tested the substances to determine what they were. So there's only one new law enforcement officer that was added, and you made it sound like there was 12 to 15.
I'm asking where's their accounts of being on that scene? It only shows those few officers where there was a whole lot more. Like I said, before I could put the gear shifter in park, there was a splash of a targeted, coordinated event, not an everyday ordinary traffic stop as my counsel told me it was. My tag light was not out of place, nor was the tag. It was right on the bumper.
I'm not asking you anything about the facts of the case, sir. Mr. Walterman, have you ever seen a criminal trial? Have you ever seen jury selection?
No, sir.
Do you think it might be an advantage to have a lawyer who's participated in trials and jury selection to aid you through this process?
I couldn't afford an attorney that was in my interest.
You understand that at a trial you have the right to remain silent?
Yes, sir.
And do you understand at a trial you have a right to testify and tell your side of it?
Yes, sir.
Do you think it might be an advantage to have a lawyer to counsel you on as to which one would be better for you and give you the pros and cons of those things?
Yes, sir.
Okay.
Had a lawyer, but I didn't receive any sureties or counsel of upholding nature.
I'm not sure what you're saying. You're going to just be a little louder, Mr.
I
Walter.
wasn't presented with any factual knowledge or, how to guide this case with counsel, other than she wanted me to commit perjury and be extorted for $1,000 to accept 2 felony drug charges that I didn't possess any drugs for to begin with.
She wanted you to commit perjury and be extorted.
Well, that's what admitting to guilt, would have been committing a crime to say I'm guilty. That is perjury, isn't it?
Well, Mr. Walterman, most people who enter a plea in my courtroom end up pleading no contest, which means they're not admitting their guilt, and they're doing so because it's in their best interest. Not admitting their guilt at all.
But I am not guilty.
Oh, I understand. I'm just... Do you understand that a lawyer can call witnesses for you and make sure they come to court? I need an answer, Mr.
Yes,
Walter.
sir.
Okay. The microphone doesn't pick up nodding.
Yes, sir.
Do you feel that you could question witnesses who appear against you?
Yes, sir.
Okay. Have you ever cross-examined a witness before?
No, sir.
So based on my earlier questions about knowing the evidence code, wouldn't it be helpful to have someone who is familiar with the evidence code question the witnesses?
Would most certainly be helpful.
Okay. But you don't want that advantage?
Yes, just counsel would be just fine with me. I was stating I haven't received that.
Okay. But again, I've asked you if you had an issue with your lawyer, and you said you just want to represent yourself.
Well, my best interest wasn't being looked out for. That's why I was needing to.
How so?
I did the work, studied the case law that backed up the findings for my plea of not guilty for every account with extra backup on it. Gave her the motions or told her
Case
which
law for
motion-
your plea of not guilty?
Well, that was backing up the case that I'm fighting right now for my freedom, and the charges that was put against me, stating what made those charges not of any merit or substance. And I wasn't getting nothing but, this is the best I can do, plead guilty to something you're not guilty of. To target individuals in Florida to do this type of extortion or bullying or gang stalking.
Who's gang stalking? What does that mean?
It's where a group of individuals conjure or coordinate coincidence to attack a being, to take advantage of it.
You're saying someone's doing that to you? All right. At this time, based on what I've heard, Mr. Walterman, I can't find that you're capable of representing yourselves in this case. In fact, I think an evaluation might be in order. Because I'm not sure you understand what's going on here.
I certainly understand what's going on.
Well, based on my readings of what you've written in your pleadings and your answers to my questions today and your allegations of gang stalking and corruption against you, but you've given no reason why that would happen or even really who's doing it, I've got concerns as to whether or not you can really handle this case on your own, number one, and whether or not you're even capable of entering a plea or going to trial.
So can you appoint me some just counsel? So, that's going to be
I
fair within
have.
the law.
You haven't told me anything that's wrong with your counsel. Other than just to say this kind of conclusory statement that they're unjust.
I'm not guilty of the charges, yet I was asked to plead guilty to 2 felony drug counts that I didn't
Were you
possess.
asked to plead plead guilty, or were you told what your plea offer was?
Just that was the best that she could do.
Okay, and sometimes the best that can be done
Break
is
the
not.
law and pay them $1,000 to just walk away.
Again, I just don't really think you understand how this process works, and your lawyer's trying to explain that to you. And at this point, I'm finding under a Faretta inquiry that you're not capable of representing yourself.
Okay.
Ms. Rivers?
Your Honor, the issue remains that he refuses to get the evaluation. I've tried twice for the evaluation. He refuses to get the evaluation.
Is that the one you've tried to do internally?
Yes, Your Honor.
All right, then I'd like an order appointing
Yes, Your Honor.
a doctor to do that evaluation. And Mr. Walterman, I'm going to order you to take that evaluation. And if you refuse to do so, you'll be held until you agree to do it. Because it's concerning that you're refusing to follow your attorney's advice in doing this. And now, from what I've heard, I've got the same concerns that you may not be competent to proceed. Anything else, Mr. Walterman?
Sir?
All right, I'm going to put it on October 29th at 9. I would like that order so I can sign it certainly this week, Ms. Rivers, and then they'll send someone out to talk to you at the jail.
All right.
It may be done by Zoom.
What about new counsel?
Again, you haven't told me anything other than a conclusory statement that she's unjust. So I'm not going to remove her from your case and add someone else until you show me that she's done something wrong.
Kind of hard to show you any evidence. Stuck at the county jail. I talked to her. They come and stole all my paperwork, destroyed all the stuff, my property, immediately after I talked to her the first time. And I finally got a rediscovery, and it showed that it's been re-amended after I spoke with her again and was telling her some of the facts of the case that would be presenting my innocence.
Discovery is amended all the time, Mr. Walterman.
Yes, that's right.
As they add an officer who they didn't initially know about, or adding someone who's new as far as an analyst who's looked at substances, or like the chemist that was added in your case. Those people weren't witnesses until they became witnesses during the course of the case. I can tell you, as I was a prosecutor and a defense lawyer before I took the bench. I've had cases where we've had 15 to 20 amended discovery exhibits, depending on what the case is. It's just part of the process.
What about a fair and just due process? We were supposed to go to a trial a long time ago, and they keep putting it off.
You've missed court twice and been failed to appear twice. That's why you haven't had a speedy trial. You were set for trial back in March, and you didn't appear for your docket day. And because of that, I issued a warrant for your arrest because you didn't show up. And that's why you're sitting in jail, because you're a flight risk at this point after 2 times missing court and have to be rearrested. Anything else, Mr. Walterman?
No, sir.
All right, thank you. October 29th, 9 o'clock.
Thank you, Your Honor.
Make sure you comply with the evaluation that the court's ordering you to take.
Your Honor, may I approach with the state?
Yes. All right, who else do we have?
Your Honor, this is Mr. Vernon Robinson before the court in 25 CF 577. We just need to try
Finish
again on
up?
his plea agreement from this
Sure.
morning, Your Honor. If I may approach.
Yes. All right, Mr. Robinson, I swore you in earlier, but let's just go ahead and do it again on the record. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
All right, and Mr. Robinson, we previously went through this plea agreement, and literally on the last question, you kind of made a joke about the fact that I asked you if you understand that you could be deported if you're not a U.S. citizen, right?
Yes, sir.
All right.
And I apologize for that.
All right. And I accept your apology, but here's the thing. I just can't have my courtroom turn into that where people make jokes about it. It's one thing when something gets said and it could be a little bit humorous. It's another when I'm asking you questions about your rights, and that's when it happens.
Again, I apologize.
I understand. So, did you go over this plea and sentencing agreement?
Yes, sir.
With Mr. Maddox, your attorney?
Yes, sir.
All right, and I asked you all the questions before. You're satisfied with what he's done for you?
Yes, sir.
All right, and you know what's going on here today?
Yes, sir, I do.
Okay, and has anyone forced, pressured, or threatened you in any way?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand there's not going to be a trial if you take the plea?
Yes, sir.
And do you understand you're waiving all of your trial rights, which are on page 2 of that agreement that you signed?
Yes, sir.
And you understand you're waiving all potential defenses you may have had?
Yes, sir.
Do you have your answers to any of the questions changed from the last time I asked you these a couple hours ago?
No, sir.
Okay. And, the big question is, do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. You want me to go through the plea conditions again?
No, sir.
Okay, you already know those from
Yes,
reading
sir.
it before and me going through them before with you?
Yes, sir.
Okay. All right, so what is your plea as to 25 CF 577? It's got your entering a plea to possession of a controlled substance, possession of drug paraphernalia, and driving while license revoked. What's your plea?
No contest, Your Honor.
All right. And in 25 CF 1087, you were entering a plea to counts 2 and 4, which is improper tag and no vehicle registration. What was your plea as to those?
No contest, Your Honor.
All right. And for the other cases that I didn't just talk about the pleas, what was the state have an
The
announcement?
state is going to be null processing those, Your Honor.
Okay. So just to make sure your null processing counts 2, 4, 5, 6, 7, and 8 in the first case, and then counts 1 and 3 on the second case.
That is correct, Your Honor.
All right. All right, so Mr. Robinson, I'm going to accept your plea as freely, voluntarily, knowingly given in 25 CF 577. 2 years of probation, adjudication of guilt, $615 court costs, $150 cost of defense. I'll waive the cost of supervision due to the fact that you've been found to be indigent and are represented by the Public Defender's Office. That's as to count 1, the possession of controlled substance, and count 3, it's adjudication of guilt and time served. And in count 9, which is the drive while license suspended, adjudication of guilt, credit for time served. Is that your understanding?
Yes, sir.
And then on 25 CF 1087, on counts 2 and 4, again, that's the improper tag and the no vehicle registration. It'd be credit for time served, adjudication of guilt, $300 in court costs, and $50 cost of defense. Correct?
Yes, sir.
Is that what you believe it was
Yes,
supposed
sir.
to be? And then the other 2 counts were dismissed. So you're only on probation for the 1 count of possession of a controlled substance in 25 CF 577. So in the other case, I'm going to give you 90 days from your release to go ahead and set up a payment plan or pay off those costs in the second case because you're not on probation for those. And then otherwise, you're on probation for the first case. Your costs can be paid during the course of that probation. And probation is going to instruct you on that. I'm going to have you meet with them now and then do your fingerprints. You'll have 30 days to appeal. This is a guideline sentence. I've reviewed your guidelines of 19.2 points, so there's no lowest permissible prison sentence. So this is a guideline sentence. And again, have you speak with probation, and then you have 30 days to appeal. Any other questions, Mr. Robinson?
No, Your Honor.
All right, good luck with everything.
Thanks, sir.
All right, Your Honor, this is Mr. Tyler Webb before the court in 25 CF 253. Mr. Webb and I have discussed the amended plea agreement, Your Honor. It will, what's going to happen is he's going to be put on probation for 11 months and 29 days, administrative probation. He'll serve the jail sentence of 11 months and 29 days as a special condition of that probation, Your Honor, and he'll complete the ECLC program as a special condition of that probation as well, Your Honor. The court costs, since he won't be able to pay them while incarcerated, will just go to judgment. May I approach?
Yes, sir. All right, Mr. Webb, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Tyler Lee Webb, March 8th, 1998.
All right, and Mr. Webb, you're here in 25 CF 253, charged with battery on a law enforcement officer, third-degree felony, punishment up to 5 years in state prison, resisting without violence, first-degree misdemeanor, 1 year county jail max, and 2 counts of felony battery, both third-degree felonies, again, punishable by up to 5 years in state prison. Do you understand all that?
Yes, Your Honor.
I've been given this plea agreement between you and the state that calls for you to plead no contest on all charges, be adjudicated guilty. You'd have 11 months, 29 days administrative probation. As a part of that probation, you're to serve 11 months, 29 days in Okaloosa County Jail, waiving all prior credit before today's date. It'll run concurrently between each of the 4 charges. While you're in the jail, you're to, are we saying complete or saying comply?
Oh, incomplete, Your Honor.
Okay. Complete the Emerald Coast Life Center program during the course of your incarceration. $967 in court costs, $150 cost of defense. Those court costs will go to judgment as well as the costs of defense. Again, the ECLC is also to be completed as a special condition of your probation. Anything that I've missed?
No, Your Honor.
And, yeah.
But what do we do about game time? So if he gets.
I forgot you weren't here this morning.
I wasn't.
One of the reasons we're back is I'm trying to make sure that all of these 1129 ECLC cases are being done somewhat uniformly, at least. My understanding is the way we've talked about it, if someone does 1129 as a condition of their probation, if they're released because they've completed their jail term, that's considered completion of the 1129. Well, I guess what we need to put in here is early termination upon release from jail.
Yes, Your Honor, automatically, the defendant shall automatically term, shall needs to be.
Yeah, that's right.
That's fine.
Shall term upon
right.
release from.
All right, so early termination of your probation shall happen when you're released from jail, on this case, having completed your sentence. But do you understand, Mr. Webb, that if you were to violate your probation in some way over the next year while you're still in jail, and that could mean, being in possession of contraband, committing a battery on a detainee or a corrections officer, or anything like that, that you be subject to a violation of your administrative probation and could be potentially sentenced up to the maximum on each of your counts that you're pleading to now.
So, Your Honor.
Okay, so as long as you're doing everything by the rules there and completing the program, it shouldn't be a problem, right?
Sir.
All right. Anything else?
No, Your Honor.
All right. And did I get guidelines on those? Yes, they're attached.
The guideline sentence, Your
It's a
Honor.
guideline sentence, so there was 25.4 points. 11 months, 29 days. All right, Mr. Webb, I'll need you to be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court. Does probation still need to talk to him? Okay.
He's released or something.
I understand. I just want to make sure that it's all clear.
Thank
You
you, Your
have to talk
Honor.
to probation as well.
Look, ma'am. Your Honor, this is Mr. Lawrence before the court in 24 CF 2858. Your Honor, I reviewed my notes and was able to come to an agreement with the state. Just want to make sure Mr. Lawrence is amenable to it, if I could just have a brief moment. Sure. Mr.
Thank you.
Sheik, I'm going to
Yeah, I
add in the
appreciate
plea
that.
agreement, no action on the failure to appear. All right. Date it 9/2/25. May I approach, Your Honor? Thank you.
Thank you.
All right, Mr. Lawrence, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your full name and date of birth?
William Ray Lawrence, 6/1882.
And Mr. Lawrence, you're here in 24 CF 2858, where you're charged with 2 counts of possession of a controlled substance. Each of them are third-degree felonies, punishable by up to 5 years in state prison. And 1 count of possession of drug paraphernalia, which is a misdemeanor, first degree, punished by up to a year in county jail. Do you understand that?
Sir.
I've been handed a plea and sentencing agreement between you and the state that would have you plead no contest to count 1. The state would dismiss counts 2 and 3 and would take no action on your failure to appear. As for count 1, the sentence would be adjudication of guilt, which is a felony conviction, 2 years of probation, substance abuse evaluation, and any recommended treatment, $615 court costs, $150 cost of defense, and waive cost of supervision. Is that what you want to do today? Is that the state's agreement?
I apologize, Your Honor.
State's
Yes,
agreement?
This is our agreement, yes, sir.
Okay. All right, Mr. Lawrence, have you gone over this plea and sentencing agreement with your lawyer?
Sir.
And did you understand it? Did you sign it? Are you satisfied with your lawyer's advice and representation?
I am, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind?
Yes, sir.
And you understand you're giving up your trial rights, which were listed on page 2 of the agreement that you signed?
Yes, sir.
You understand you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the one count of possession of a controlled substance?
No contest, Your Honor.
State have an announcement on the other counts.
State will no process the other counts, Your Honor.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. On count one, adjudication of guilt, 2 years probation, substance abuse evaluation, and any recommended treatment, $615 in court costs, $150 cost of defense, waived cost of supervision. Counts 2 and 3 were dismissed, and the state's not taking any action on that failure to appear. I need you to be to talk to probation, be fingerprinted, and then you have 30 days to appeal the judgment and sentence.
Thank you.
Thank you, Mr.
All
Moore.
right, good luck, man.
Thanks, sir.
You're welcome. All right, this is Miss Bianca McDonald approaching. She's before the court in 25 CF 1602. It's a bond hearing for today, Your Honor.
Okay.
We had pretrial detention scheduled last week. The state announced it wasn't going to go forward, and that's why we're here today.
Okay. All right, so 25 CF 1602, charged with burglary with assault or battery and felony battery.
Yes, Your Honor.
What would y'all like to tell me?
So, Your Honor, my understanding is that, it's a roommate situation, but Miss McDonald was the only person on the lease agreement. I do have a copy of the lease agreement, but it does contain her original signature on it, Your Honor, and I'm going to take some testimony about that in a moment so that I can have the court review it. But my position would be, Your Honor, that there's no burglary here because we have a lease agreement where Miss McDonald is the only one on it, and she was allowing the alleged victim in this case to stay there, Your Honor. But there was no situation where it would have been a private bedroom that she didn't have access to, and even if it were a private bedroom, as it's phrased in the arrest report, she had every right to enter it. And in any case, there's a lease agreement here where she has a property interest in the property, Your Honor. So again, my defense's position would be that it's not a burglary, Your Honor. She was previously employed at McDonald's and certainly intends to try and get that employment back. It's my understanding, and I'm not aware of any failures to appear in her past, Your Honor. She does have a house she could stay at. It's her grandfather's house in Niceville, where she would be able to stay and await disposition of the case. The most that Miss McDonald could post is approximately $1,000 cash professional bond because she has $100 she could get to a bondsman, Your Honor. She has stayed with her grandfather before, and that has been her residence for the past 15 years or so, Your Honor. So defense's position would be that she's not a flight risk and that she would show up to court, Your Honor. And defense's position would also be, as I said earlier, that the burglary charge is not going to stick. So defense would ask for an ROR on the burglary with assault or battery, Your Honor, and I know it is very serious charges as it's currently alleged, but again, I do believe Ms. McDonald will have a strong defense there. And then the battery conviction, Your Honor, we'd ask for $1,000 cash professional. If I may take some brief testimony from Ms. McDonald.
Ms. McDonald, raise your right hand. Do you swear or affirm the testimony you're about to give us the truth, the whole truth, and nothing but the truth?
Okay, Ms. McDonald, do you recognize this image here?
Yes.
Okay, what is it?
My lease.
Okay, did you sign it?
Yes, sir.
Is this the only lease that was for the property that you signed?
Yes, sir.
Okay, was there anyone else on it?
No.
Your Honor, may I approach the court and review the lease agreement?
Have you seen it, Ms. Leone?
I've seen it.
Okay, any objections?
Besides being a copy, I couldn't really read it because it's in small print, but I take it what he said.
All right, so I'll point out in reading this, and I'll accept this as defense one.
Yes, Your Honor.
Paragraph 5 states, this lease is intended for above tenant only. The tenant listed is Bianca McDonald, the defendant. And any additional guests or tenants staying longer than 14 days must have pre-approval of the landlord. Anything else, Mr. Maddox?
No, Your Honor.
All right, Ms. Leone.
As I stated, Your Honor, I'm not going forward on pretrial detention, so I will be fine with whatever decision the court makes. obviously requesting no contact with the victim.
And obviously, Your Honor, defense would have no objection to pretrial services or any reasonable conditions of bond that the court sees fit.
I guess the issue is with no contact with the victim, that victim claims that they stay in the house.
I would argue she's got no lawful basis to be at the house, Your Honor, but I understand the court's concerns there.
This is not landlord-tenant court.
No, I know,
So
I know, Your Honor. Look, Ms. McDonald would be willing to live with her grandfather, so if that's what the court feels it needs to do to protect the community, Ms. McDonald has no objection to that. She'll live with her grandfather until we can sort this thing out.
Certainly, the court can't give any sort of advice on the process of what can be done, Ms. McDonald.
Yes,
But
sir.
upon my reading, I mean, I know I've seen cases like this before where it's been considered burglary when there's someone else who's a mutual leaseholder or something like that, or even two people who own the same house. But I think this might be a first where I've seen that. I'd say at least from one person being accused of burglary of their own lease premises by someone who's not on the lease. So what I'm going to do is, I think the problem is with it being burglary with assault or battery is I have to give a cash or professional bond. And I'll just remind you that we're here for a pretrial detention hearing initially because the first appearance court found probable cause. So I'm going to do $1,000 cash or professional on the burglary with the battery, and I'm going to RR you on the felony battery. No contact with the alleged victim. You can go back once to that house to retrieve some of your personal items. Obviously, like we've talked about, I can't give you advice, but there's certainly potentially some things you might want to be able to do as far as property rights, but otherwise don't have any contact with the alleged victim. I'll put something in there as well for pretrial services, who you'll have to call into once a week to make sure that you're where you're supposed to be and they know where you're staying, because you don't really know what that is yet. I mean, it's probably going to be grandfather, like you said, but just to verify that. But also, if the alleged victim were to submit an affidavit to pretrial services saying they want contact, or that they've left the house, that you would be able to go back. Okay. Any questions on that?
No, Your Honor. Thank you. Don't go back to that residence.
What else do we have? What do you have? Who's that? Oh, yeah. That's the 3800 motion, I think. I mean, if Ms. Dudley gets here any faster, then I'd already contacted Judge Love in Walton County to make sure that she could hopefully get out of there quickly. I thought we talked about Dalton Norris already. We talked about Norris. Well, Mr. Williams?
Yes, sir.
And Dalton Norris, I see that you sent over an email.
I got some documentation from the bondsman, and I just forwarded that over. It looks like at some point she was, as I indicated earlier, referred over to Lakeview.
You step over to the microphone, Mr.
Oh, I'm sorry, Judge. I'll grant you
I could hear you. I just don't want it to be. I don't want the phone to ring and say they can't hear you on the.
way the emails are structured. It's a little hard to read. You kind of have to read from the bottom up, I think. But the way it reads to me is that she was discharged, or he was discharged from West Florida Hospital after a few days to Lakeview. Now, what has happened since Lakeview, I don't know. And I don't have anything from either medical facility, nor do I really anticipate I'll be able to. On the other hand, somebody who's a one-man grand jury and has office subpoena ducis tecum powers might be able to find something. But I no longer qualify.
Did you forward that to me too?
I think it went to Miss Lee.
I think it went to Ms. Leona. I didn't realize it was your case.
Thank you.
Is he on probation somewhere else? Because just because what you sent talks about probation can come meet with him, but he's not on probation.
Yes, I'm not sure
But I
where
can
that
see.
came from.
Okay. Just want to make sure I wasn't missing. Dalton Norris.
He's on our
Yes.
I think he's the last person on the docket.
I just forwarded it over to you. It should have the attachment.
got a KPS, but looks like he's supervising him again,
Who supervised him? I mean, from was it Okaloosa County?
so I don't know since he was passed. I'm gonna find out.
The only case I see on my docket is 25 CF 828. Which I don't see that he was ever placed on
Found these
probation.
up here.
Yeah, no, I have them up there. Thank you.
We talked about this earlier as well, that there was already a capias for him from June 23rd. So I'm not even sure why he's on this docket in the first place.
I'm not either, Judge. He was on the docket, so I pulled the file and started looking into things. And then we'd gotten the email from the bondsman, and that helped clarify some stuff.
The state can do some research, but I mean, as of right now, I think best is just to keep the KPS on, Your Honor. What do you do as far as the email hasn't come through? I'm guessing it's. No, I believe you sent it. I think it's just taking time.
So it should go through.
Your Honor, we haven't supervised him since 2017.
Yeah, I didn't see anything. Yeah.
I'm just keeping everybody in the loop, Judge.
The only one that might have is, I think he pled to a petty theft. And what is 66?
Well, it doesn't matter. It just said probation could go meet with him, but he doesn't seem to be on probation. So so he's got the capias outstanding. If you find something, or the bondsman does something,
Yes.
I'll consider withdrawing it. But until he shows up in a courtroom or turns himself into the jail, I just don't know what else to do with him.
Yes, sir.
Because it's been 2 months already. Anything else that we need to take care of before 3:30?
No, Your Honor.
Oh, who? Billy Jack Harrison?
Jack Harrison?
Billy
Billy
Jack.
Jack.
Yeah,
One
you
sec.
no-prossed it.
It was
It was
dismissed, Your Honor.
no-prossed over a week ago.
Okay.
Yeah.
It was no-pros. In fact, we announced the no-pros at the pretrial conference day.
Well, there's a clerk's minute sheet that says today's date for status. I don't know if I have notes.
I'd have to go back to the office to get it, but I have a copy of the no-pros.
I have it also. I just, hold on.
And my note says he wasn't here on the 25th, and it was a possible no pros, but I'm not sure if it was actually.
May I approach?
No, if you filed it, y'all filed it, and you just announced it.
I think the state announced it the next day.
This was the day after court, though.
Yeah.
This wasn't done in court.
Yeah, it wasn't.
Well, she announced it when we were in, whatchamacallit, miscellaneous BOPs and arraignments the next day, Judge.
The 26th.
It
No,
says
he's
it's the
not.
26th.
That was supposed to be regarding the 3800 motion. Which, I'm not sure Ms. Rivers is. That was just added from last week.
You need to text her, Your Honor.
If she'd like to try to address it, sure. Otherwise, we can put it on Thursday. It's just about jail credit and sentencing score sheet stuff. I reviewed it all.
What was the name?
Tony Tatum. I've got two cases that were set for trial that we didn't address because they were set directly to docket day. You've got Hinesley, Mr. Williams. Is that
I
still,
do, Judge.
you still expect that to go?
I do, Judge.
And then Ms. Rivers had Stiverson, but she's on here. I just wanted to, trying to figure out how many trials we've got so we can maybe come up with a schedule that'll work.
What's the name of that other one, Your Honor? Stuyvesant?
Stiverson, 25 CF3. Because with this many potentially set, I may have to get back up myself.